Good afternoon. Welcome to all of you to this seminar organized by our Philip K. Wong Center for Chinese Law of the Faculty of Law here at Hong Kong U. So welcome to both of the audience who are in person and also online. I think there are more than 30 or 40 people online. And those who are online can also turn on a switch to look at the transcript or the translation of the seminar. And you can also have the option of choosing whether you want to see the subtitles in English or in Chinese. So may I first introduce the speaker and also the topic. The topic is the future of Tso and Tong. Actually, is an aspect of the law of the law of land and inheritance in the new territories of Hong Kong. I remember that even as a student, I learned a little bit about this, but my teacher at that time were no experts in the topic, so they know very little. So I learned very little on this topic. So the speaker today, Dr. Max Wong, is an expert in many fields, and the new territories land law, the Qing law as applied in Hong Kong, is one of his main areas of research in recent years. But actually, one of Dr. Wong's book is called Reordering Hong Kong, published in 2017 in the UK, and that's about the history of the making of the Hong Kong Bill of Rights Ordinance. Is that right? It's about the Bill of Rights Ordinance, which was enacted in 1991. So you see that Dr. Wong has a very wide academic interest. His more recent works include a book published by Springer in 2020 on the legal abolition of concubinage in Hong Kong. I also remember my studying this topic as a student here in the law school in the late 1970s. And I remember my teacher was Leonard Peck, and he taught this topic. So his more recent book is Legal Pluralism in Qing China, published by Brill 2024. But I believe that that book is also relevant to the application of Chinese law, Qing law in Hong Kong new territories, right? So it's not just about the Qing dynasty in China. I believe that Max is also working on another book on the application of Chinese traditional law in Hong Kong, which will be published in the foreseeable future. In the meantime, he is teaching on a part-time basis at our faculty. His course is called Legal Pluralism in Hong Kong. Is I think an LM course. So we can also advertise the course for the current and prospective LM students here. Actually, Dr. Wong used to teach in the Faculty of Arts of Hong Kong U, but he's now is it ordinary resident in the UK? So we don't have the privilege of hearing Dr. Wong here teaching in the Faculty of Arts. So so without further ado, I will now hand over to Max. So you speak for maybe 40 minutes or so.
Yeah,
we can have Q&A.
Can be a little bit less, depends
Yeah.
on the audience. Thank you very much for coming. This is part of my research. And in fact, I taught this part last week in the LLM course. So to be honest, I just took the materials from the lecture outline and presentation. So you will find it very strange. It's not catering actually for the seminar. So thanks, Professor Chen, for inviting me to this seminar. Actually, this is not my research topic, basically, because you will see from my brief CV, I worked many times on the marriage law and traditional marriage law and family rather than inheritance. But basically, because of the fact that I was asked by several lawyers to be the legal expert, so I called my PhD supervisor. In fact, I just take some of his insights. So if you have time, you can read my PhD supervisor, Professor Michael Palmer, who actually taught here for a long time. He was my sifu, so that's why anything happened, even my PowerPoint, he would criticize me for getting too less to all of you. So anyway, I just took about 70% of his energy. And if you really, really enjoy getting the traditional Chinese law, I will ask him to come and to the law faculty to give his insight. So today I will go for the Tso and Tong revisited. So in Mandarin, we always call it Zhu and Tang. I was asked to write in Zhu and Tang when I write the materials in English, because that would have more audience with the mainland Chinese, of course, and also with the Taiwan scholars. And today there are so many issues there, but I will focus on one issue, will be widow and daughter's rights. And the third one will be conclusion, and then one, the discussion. So first of all, I would start the traditional Chinese land use. Well, this is an approach different from other book. If you really want to construct a book on Zhou and Tong or Zhu Tang, you would consult possibly from Malcolm Mary. He has a book called Unruly New Territories, and he retired, so he was in UK as well. His approach is to use Zhu and Tang or Zhou and Tong as a social institution or as an institution register in the new territories. But that actually caused a lot of confusion, because in mainland China and in Taiwan scholars, their approach is totally different from Hong Kong. They read this from the angle of the traditional Chinese land use. And that's why, for the purpose of getting dialogue with them, I think I will use this approach rather than Malcolm Mary's approach. All right, so that the scholars from China, scholar from Taiwan, will have the same language. Otherwise, we'll be in big trouble when they came over to be our expert opinions or making expert ideas on the part. They were very confused. On the other hand, when we go to China or go to mainland China or Taiwan, we do score any academic exchange. We also face the same difficulties of telling them what's going on. So for the purpose of my students, I use this approach because they can read Chinese. And when they encounter Chinese materials from China, they have big trouble on their mind, how they get to understand the concept. So I use this concept from here as a mainland scholar or mainland Chinese scholar. They will understand very well since they studied that in their LLB. They call it Yi Tian. So there are many Chinese land use there in traditional China, one of which is called Yi Tian. Yi Tian stemmed from the situation from Song Dynasty when they tried to do some social welfare, right? So without a modern social welfare system, how would you get the money for charity use? How would get the money for school use and anything else? They would have a concept called Yi Tian. We barely translated involuntary or welfare land, or in some occasion, they would translate it as Zhu Tian, clan land. So when you look at clan, when you look at voluntary or welfare, that kind of translation, you can see the purpose of the land, right? So that would be for use of clan and for the voluntary welfare land. But let's put off all the other names on there. Yi Tian is a big concept on the top. So there are several purposes of the land that could be regarded as Yi Tian. So if you put the land for the purpose of building a school for education, they call it Su Tian, education land, right? So if you put the land building a big temple there, I like the Buddhist temple, I like the Taoist temple, because I strongly believe in some religious affairs, they call it temple land, right? So you have that concept, temple land, education land. So if you want to build something on grave, Richmond, they got grave, right? Wow, very big land for grave. That should be That should be, they call it grave land, right? So they have a grave land. That is the purpose of that voluntary purpose. We call it Yitian. There are several purposes and there are several pieces of land. But most important of all, this is the land should be used for the purpose of Jitian. So ancestral land pops in there. So that is a very important. So Jitian is the main purpose of all these Yitian, because ancestral worship is the utmost important thing for a Chinese family, first of all, and also for clans, for kinship. So ancestral purpose. Remember, put this in mind on your brain and everything else. You have to understand this concept first. Ancestral purpose, right? So without getting to the new territories, I use this part for you to understand our land use. Of course, because of the time, we won't touch on so-called skin land and bone land, right? I just put up all these traditional land concepts, but that is the purpose of the land, right? Remember that. And there are two ways normally by doing the ancestral land. Two ways. One will be established by the family. So another one will be by clans, clan members. So we have two types of basically, or at least two types. So how will we do the ancestral land for family? So for example, I die tomorrow. So before that, I will tell that, look, some of my lands will be taken out from my property, and that will be the land for the purpose of ancestral worship, right? Ancestral worship. So put my big face there with a big photo, then otherwise I have to write something that land belongs to the ancestral worship. And well, you won't do ancestral worship every single day, right? Basically, they will be on the spring or autumn. And and the land will be owned. Well, because of the modern property concept, where the thing owned by whom, right? They will be owned by the family, right? Because in traditional China, there is no individual property. There is only family property. So that will be owned by the family. And that ancestral land will be used for ancestral purpose. All income and proceeds from that land belongs to ancestral worship, right? So in modern concept, if I have the land, of course, I will do as a car park, BBQ park, or any park you like, right? And all this income from the car park, BBQ park basically will be used for ancestral purpose. I don't know how much nowadays people in new territories will be used that money for ancestral purpose, but basically they should be used for ancestral purpose. Extra income from that part have to, sometimes they will distribute it among the son, or they will save in the areas like a fund, right, for other public purpose. So there's a family angle, but remember that, family. However, there are different types. For example, one may think that we have that wealth because we want to pay our tribute to our ancestor coming from mainland China 1,000 years ago, and this is our focal and basic, the big ancestors, right? So I don't have the money, but I have to show my a sort of faith. So I collect monies and ask my same people from the same clan, for example, the sons, my uncle, and other clan members, join together, pool the money, and buy the big piece of land for ancestral purpose, right? So this is not a land for family. It's a land for the whole clan. And this kind of land, a whole clan, of course, you have to buy, right? And how would you buy that? Well, in traditional China, we don't have foundation concept, right? We don't call it 基金會, we don't call it 基金會. There was no 基金會 in Song Dynasty or in Qing Dynasty. You have to put the name on that. So normally they will put the name of Tong, right? Tong. So that comes the term Tong, right? And sometimes they will use 會, WUI or HUI, depends on which Mandarin or Cantonese. They will have different sorts of name for the social institutions. So Tong is one of the way they do it. And also they would sometimes do the name like Wui. So that's why I was asked to deal with a situation, a case called Wui, and that's the point they do. But since they are all on, since the land will be used for ancestral purpose, normally this is owned by Tong, right? Remember this one, right? Oh, okay, so remember that. So and then on how we manage the land, and for the family side, family, say like I died, I got a family land. For the family side, that would be used normally by rotation between the son. So 3 years for A elder son, and for the second son, another 3 years, and also another, the third son, 3 years. So a rotation purpose. Well, I won't go to the detail, but that we call it rotation. Sometimes 5 years, sometimes 10 years, depends on the family arrangement, right? In Chinese term, they call it 直年, 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 直年. So this is a family side. On Tong side, I mean the big size one, right? Very big size Tong. Somehow they will appoint clan members. And sometimes they have, for rotation, sometimes they have find someone to manage the land, right? I put it there first, I pause it here. But most important purpose, remember, will be ancestral purpose. That's why I have to emphasize that, right? Okay, if you understand that, then we have a follow to this part, we go for the land registration system in the new territories. If you take my course, it takes 1 hour to discuss, but I'll just give you a very quick look on the part. There was a land survey after the British government came to the new territories. Well, not 1899, somehow 1900, it depends, or 1903, depends on which book you follow. There was a land survey, and Lockheed report 1900, he has a report on the ancestral land, right? And look it carefully. So it is a land originally set apart from ancestral worship. That's correct. Increased by purchase from time to time in the name of deceased ancestor. Correct. In those names, also the government taxes are paid. Well, depends on land, whether it's a skin land or bone land. Well, that's question mark. The rent of ancestral land is devoted to upkeeping of ancestral temple. Correct. To the education of members of the clan. Well, there's a mixture of land use, right? As I said, ancestral land is basically for ancestral purpose. But now Locke said that is this education of the members of the clan, and that should be called education land, 书田 or 虚田, right? And to the worship of ancestor, yes, that's correct. Or relief or poor members of the clan. It depends, because sometimes for the ancestral land of the big clan areas, or we call it clan areas, somehow those land might be rent out to the poor members of the clan, so they for kind of some sort of social welfare purpose. And marriages of expenses, there's a mixture of this one, because marriage of expenses of doctors belongs to 养老份, 养老份, or not 养老份, is called doctor of jewelry. So that's another pieces of arrangement of the land. That means the part of the land will be separated, and the income will be used to support the mother and doctor. For the mother until she died, for the doctor until she got married. So it is not the purpose of ancestral land to give the money to the doctor for the marriage. And that's why Lockheed report got a mixture of different uses of land use in China. And that poses a problem nowadays, because that report dictates the way how New Territories Ordinance operates. And that is totally different from things happen in China, right? And that's the point. Such land is always held in the name of ancestor who bequests the property, the land being nearly always leased to member of the clan who cultivate it and pay a yearly rent. That was halfly correct. Because for the family ancestral land, it will be cultivated by the sons in rotation. So it is not renting out. For the clan's land of the ancestral land, they may rent out with pay the yearly rent. So it's a mixture. You will see that quotation. In 1900, when Lockhart went to the new territories to do the land survey, he did not have that enough information, and there was a mixture of the land use. It would probably reflect during the time in the new territories, lands during the time they were used in a mixture of different use in different situations and causes confusion now. Well, I'm not trying to accuse them because they don't have time, they don't have the knowledge, they don't have the experts, but I do the research on this understanding of ancestral land with how Japanese government went to Taiwan and make the land survey. And it seems that Japanese government make a very good categorization of the usage of land based on traditional land use and not the mixture of different land use as you see now in this report. So we have problems. And that is the problem. And the second problem is that the manager was not mentioned in his observation, right? You never see manager there. But how come manager appeared later on in the New Territories Ordinance? Remember, took it seriously, no manager there. Remember, we go back to the definition of family, clan land established by family. That will be cultivation by the sons in rotation purpose. No manager there. But why there is a manager in the New Territories Ordinance? In the clans part of the ancestral land, yes, somehow, sometimes they will be managed by rotation of clan members. Normally, they are senior members. They will manage the land, but they give the name of Xilei, but not every big clan ancestral land, they have manager. Remember that, very important. And so, manager was not there, but it was given in the New Territories Ordinance. That causes confusion, second confusion, right? Because in the family ancestral land, for example, as I said, the different sons, right? Unfortunately, if there is only one son, he will be extremely busy. He will manage his own land and also in the ancestral. But if there are several sons, they will do it in rotation. But who is the manager? The son is the manager or the mother? Or every 5 years you change the name to the government, right? Or you put all three names of the son together. How about they got a grandson? When the son died, the sons of the son, that means the grandson of the ancestor, is now responsible for managing the land. You will change the name again, right? And that causes confusion now. Why? They can't find a manager because it is a family-owned ancestral land, right? It's by rotation purpose. And that is the way causes one confusion. And second confusion is that every Tong, during that time, as I said, some of the ancestral land made by different members of the clan, right? It's a big area, big clan, big ancestral hall. But the manager, they say that, oh, we must have a manager. So they have a manager called Xilei, but not every Tong or Wei, they have manager during that time. So in fact, you are asking those traditional clan of the ancestral land to find a manager, right? So that not just happened in the new territories in the British Hong Kong, it also happened in Japan when they occupied Taiwan, when they tried to do the recategorization of land use. They also asked those people that own the ancestral land to appoint manager. In Taiwan, they call it 经理人, 经理人. In Hong Kong, they call it 司理. But these two colonial authorities make the same thing of asking those guys to appoint a manager. Why? Because of the administrative, I think it is out of administrative convenience. They don't want to deal with the owners. They ask them to do manager. And that's why we have the problem now. And the problem happens also in Japanese colonial period in Taiwan. I won't go over Japan because this is not the person presentation. You can listen to my course later. If you subscribe my course, I will tell you something about it for comparative perspective. So in the new territories, section 15, they say very clearly, whenever any land is held from the government under lease or other ground, blah, 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 name of a clan, family or Tong, such clan, family or Tong shall appoint a manager. And that causes big trouble because we don't have so-called managerial system for managing the ancestral land in the past. And one very big misconception is that when I explain this idea to a friend, she asked a question, oh yeah, it's a professional manager, third party, right? I say, no, there is no professional manager in the past. So let's see how they deal with ancestral land in the land court in the past. 1954, when, oh, you can check the file. For the colonial officer in assistant land officer, they have a paragraph like that. So it said the ancestral land, that means 正常, will be purchased and will be established before the death of the jiazhang and father. Well, in fact, there are both ways. You can establish before his death or afterwards by the son. So I won't go over that because we have time. So this is a chart I borrowed from 1988, the report of the new territories. You will see how confused now in the new territories ordinance of the registration of land, right? So on the left-hand side, sorry for the blurring, but you can see Zhou and Tong, Zhu and Tang, they cover ancestral land, 祭田. They cover the grave land, 坟田, and also the side of Ding land, Sun land. So you see the confusion there, right? And they have Miao, Ji, Miao, Miao, Qi, Se, Gun, Gong, Yan, something like this. They're all temple land, right? Miao Tian, Miao Tian, right? And we have Wui, non-charitable business or investment partnership association, 合會, 合會, and also land loan association, 標會, 標會, right? Remember we have a regulation of 標會, right? We have for charitable bridge association, 橋會, because you need to build a bridge, you establish an association, pool the money from the clan members and build a bridge, 橋會. For the maintenance of the bridge, we have to keep certain land to rent out those areas to small shops. So we have 橋會, right? We have parents association, 父母會. What does it mean? Because we have poor family, poor doctors, poor widows, we need to pool money to support them. So 父母會 for orphanage. We have 社會, 學會. We have gangster, 幫會, also part of the 會. So 會 is there. And they have company under New Territories Ordinance. We have Gong, right? Another social institution. So I say it depends on the land use. And we have shop, and we have Wai, W-A-I, Wai. And then they have, now they got a new thing called Heung, H-E-U-N-G in a new case, not new anyway. So this is how New Territories Ordinance, at least they have so many different names under this registration. Right, and well, Dan Mankey is a very important case. I put the case there because I very much agree with the expert opinions by Professor Zhang in Taiwan, Zhang Weiren. He mentioned clearly that he did not agree with the classification by Malcolm Murray by using Tong to embrace all different social institutions. You will see Tong is not an upper concept. It's not an umbrella concept. Tong, Wui, Hung, and everything, they're on the same level. But in Malcolm Murray's book, he put business Tong at the top. And that is troublesome, even more trouble, because in traditional China, Tong is not an upper concept of all these social institutions. But it's a good book, so you can read. Good reference. So we tackle this case in 10 minutes. And I just tackled this case in Songbo, 2018. Probably DOJ would already resolve that. But let's look at this case. This is a case reported in 2018, and it also becomes today's lecture theme. It's about women's rights. So look at the report. They said that 绝房, extinction of household. So that makes a lot of trouble of the piling of files on the appointment of ancestor. Well, 打鼓嶺, I always distinguish 早堂. I always use 早 and 堂. That's why, because we're talking about two concepts. And we'll talk about 早 later, about the confusion. Again, the first of all is 早堂. He has a question because 早堂絕房之後呢, after the extension of household, the Home Affairs Department refused to make registration and something like this. And also the second issue is that for the inheritance posthumous adoption, we call it technical term, posthumous adoption was abolished, and that's why the nephew of the nephew could not succeed to inheritance and succession to the property. And thirdly, there will be a jit form. So for the extension of household, for example, if one form has extended, then in the past another form can be the Sile, but it won't be. The Home Affairs Department refused to do the registration. Of course, it's a bit confused, right? Because I think the journalist didn't quite understand what he or she is talking about. So we have to do it legally. We are the trained lawyer anyway, so that's the issue, right? So the first issue is that after extinction of household, the nephew of the deceased father cannot inherit or succeed the property. So it refers to the inheritance rights of nephew under Article 78.2 of the Great Qing Code. So the second issue is that after the death of widows, the nephew cannot inherit the property of the deceased widow. That is also Article 78.2 of the Great Qing Code. And the third one refers to the appointment of manager, partially related to 1.2 and Article 78.2, but it also refers to a case called Mak Lai Chin and Lai King Yao in 2009. So it's a partial situation on issue number 3. So in fact, that would be the issue of Article 78.2, right? So Article 782, let's look at Article 782. Article 782 is called, in Great Qing Code, is 立的子為法, right? In Chinese, we have to do it one by one, right? As I tell my student, one must be carefully stated. In China, we have very good legal writing skills. It depends on your interpretation or your understanding of Chinese, right? Don't ever try to say Chinese law is backward, no value, blah, blah, blah. It's technical, and this is very technical. So, sorry, I will use Cantonese here. 婦人、夫亡、無子、守志者，合成夫分，雖憑族長，擇超目相當之人繼嗣。其改詐者，夫家財產及原有莊連，並聽前夫之家為主。So look at Jamieson, the book that actually being quoted time after time in the court. Look at the translation, right? 婦人, widow, probably not, right? 婦人 includes husband and concubine, so that shouldn't be just a widow, not a widow, right? Left without a son, correct? Not remarrying, correct? But not remarrying means 守志者, maintain chastity. Very important, because from Song Dynasty, the emperors always praised and support those women with chastity as a good way of reflection of Confucian value of filial piety. So that's why they call it 守志者. It's a technical term. We used to translate that and maintain chastity. So should be entitled to a husband's share of the family property. Partially correct, because if there is no son, then the property belongs to the big family and there is no portion, right? Not share. It would be whole. And secondly, it shall rest with the elders to select a proper relative. Wrong. Because look at the third stage, 衰朋族長, and this is technical. It is the right of the widow or widows to appoint an heir. Yes, that's the point, right? So we look at carefully about 78.2, look at this case. Well, I'm not good in PowerPoint. That's why I make such a long time of doing that. Women, husband died, no son, chastity. The next step, inherit or succeed husband's property. That's my interpretation. And women appoint an heir. And that's the last point. The village head, 族長, consent or approval. You may ask the meaning of 超目相當. What does it mean? 超目相當 means when you go to the ancestral temple, going to the same generation, on the left-hand side is called muk, on the right-hand side is called 超. 超物相當 on the same generation of the part. So 超目相當 means same generation. Anyway, that is the way we do. Let's look at the points, 衰朋族長, the power of village head, whether he just need to consent or whether we need his approval for appointment of an heir. So appointment of an heir, in technical terms, we call it posthumous adoption, right? Remember this keyword, posthumous adoption. Well, we won't discuss the issue of adoption, whether it's a correct translation, because adoption in Hong Kong is called 領養, 領養. But in traditional China, it's called 收養. 收養 and 領養, they're talking about different things. 收養 means within the same surname. 領養is we are talking about different surname. But in British colonial law, they mix together called adoption. But anyway, we won't discuss the adoption law here in traditional China. We talk about the power of village head, right? In Dali Yuan, appeal number 1160, they said that why they put the clauses of 族長, 族長, because it will have to show justice, right? But very important judgment in 1915, Dali Yuan, appeal number 687, they said that the heir appointment is the right that is exclusive to the widow who wants to maintain chastity. The village head should not intervene without cause unless there is unjust and unfair in the process, right? So for this part, Dali Yuan mentioned clearly, 族長 can only have some sort of, I would say, consent or rubber stamp, right? It's rather than the final approval right. But let's take it carefully. In Qing Dynasty, in traditional China, all this will be done by mediation rather than go to the court, right? No one goes to the court to ask for the appointment of heir. That's very important. They will do it by mediation. I highlight this part of the right rectangle there. That means 超目相當. So if on the left-hand side, adopter, so that means personal, 己身, that means myself, right? They will adopt the same generation, that means the same generation there. And look at brothers, downwards, you will see nephew, right? So so for a family, they have to adopt a nephew first. If there is no nephew, that means the Tong nephew, right? Tong nephew. I think I put a wrong triangle. That would be on the later part, right? And then we have another nephew there. So they are all nephew. So in fact, the first one that succeed in posthumous adoption should be the nephew. Oh, okay. Or you can go to Jamieson book, page 22. I make a wrong triangle, rectangle here, but anyway. And then we look at Article 88. Remember Article 78(2), appointment of nephew to be the successor. That should be the nephew. If no nephew, there is Tong nephew, right? Tang兄弟, the brother of my father's son. Yeah, that's another way. We go on this side. Remember them. The first one will be the nephew. And Article 88 said that I won't go for the details of the Chinese term. Let's go for the English. When a husband becomes extinct and blah, 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 and there is no son who could succeed the property, all the daughters shall inherit the property. Very clear. If there is extinction of household, no son, no nephew, no other nephew. So there will be extinction of household. And all properties will be given to the daughters. 亲女 daughter, including married, including unmarried daughter, right? If no daughter, that means after reporting to the magistrate and shall be forfeited. But anyway, there's a bit translation error. 捉捕充公, 捉捕着捕, that means the discretion of the government, right? Not actually forfeited. Well, it's a translation, but I just take the court translation of New England case. So in New England case, there is an issue. X died in 1943, left a wife and 2 daughters. Widow died in 1987. The nephew sought the court to declare that the nephew could inherit the properties. They call it posthumous adoption. Remember that? And the court, after analyzing the Qing law, one of the reasons is that after 1972, the adoption ordinance disallowed the posthumous adoption. So daughters can inherit the property. So what does it mean? Let's look at this one. So in my view of the adoption ordinance, I'm fully aware that Chinese laws and customs apply to Hong Kong, blah, blah, blah. So the point is deletion of that protection. That means for the court, it means adoption ordinance actually abolish posthumous adoption. For the 4th line, it is no longer possible to have a valid posthumous adoption in this time. And we look at the chart, right? You will see what's going on. Actually, the law of adoption ordinance abolish posthumous adoption and become the doctor. Okay, and then quickly, and then the second case, Qing Wong development, they have the same judgment, making the doctors the right, and including married doctor. In this case, the father died in 1975. The first wife died earlier. So the second wife, Lam here, FY, and then the first doctor, ST, died before second wife, Lam. So they have a son called Yu, ST. ST, here, she has a son, Yu, and Yu and FY ask for the inheritance and succession to the title and property here. And there's someone called Charles' brother as nephew, said that, well, that belongs to me. Well, belongs to me. The point is, the court make the same judgment. So, sorry, adoption ordinance here, no posthumous adoption. The nephew could not succeed the property, sorry. And so after this part, if I have time, I can explain to the village head in Sa Tau Go, saying that after the extinction of household, nephew or the deceased cannot inherit the property. So how about inheritance right? So I will explain to our village head said that the adoption ordinance abolished them. So this practice no longer exists. You cannot go to the court, never again. And after the death of widow, the nephew cannot inherit the property of the deceased widow. I would say, again, you have to say same for the first question because all belong to the women now for the doctor. For the appointment of manager, originally 2 brothers and manager. After one brother died, other son generation of the same kindred cannot succeed as manager. I say partially yes and partially no. The issue is that once that property once the property belonged to the doctors, and that Tso institution probably dissolved. So how can you appoint a manager when the property belonged to a woman? And no longer for inheritance and all this ancestral purpose. So I can explain to him that, look, that's the purpose. And that's why, well, I hope I can finish on time so we can have questions. Yeah. Yes, finished that. So that's for the question Q&A, right? Yeah. Huh? Future? No. Well, I'm sorry. That's I of this case. Well, the contemporary indication is that for every Zhou and Tong, you need to find doctors to confirm whether she has a succession right or inheritance rights, and make confusion, because if you cannot find doctors, the government will say, well, it is not a little bit proper. If you put the same question to DOJ, if I were working in DOJ, I would say, could you also find out whether this particular widow has daughters, or whether that particular Tong has a doctor to succeed? Otherwise, it will feel improper, right? And managers, they may sort out to find out the doctors. That's the first issue. But there are also a lot of issues. But this is one of the issues I try to tackle to the reporter. And also, it is a very big implication. And it explains why government during that time was so reluctant to make succession of manager, because of this case. And because this case happened just because of the adoption ordinance. So it breaks down all the succession line in traditional Chinese law. So that's one of the issues.
Maybe in addition to this point about the Jute Wu extinction of household, maybe you can also supplement what you have talked about by talking more generally about what's the current situation of the law on Zhou and Tong in Hong Kong, and how the bill on the development of the northern new territories may affect the existing law on Zhou and Tong. I think because, as you know, the government's objective is to make it easier for such land to be resumed for development purposes.
Yes. Sorry. When I prepared this PowerPoint, I didn't mention about this point. One very important point of your question is the purpose of the ancestral land, right? Therefore, ancestral purpose. Why they have 100% agree between the clan or all the clan members? Because we have to find out there are widows and women as members, right? In these circumstances, women, and we have protection of women, first of all. Secondly, they are supposed to be used for ancestral purpose. They are not supposed to be used for investment. If you use it for investment, you can establish another Tong for doing investment and use modern style of 少數服從多數, right? Minority should follow the majority. But they are for ancestral purpose. You cannot imagine in an ancestral purpose you can have majority or minority. We always serve the ancestor, right? And thirdly, that land is supposed to be used forever and not sever and not to be sold. 它不會賣即係唔會賣出去。And that's why I cannot see why you have majority vote or minority vote, thirdly. And fourthly, very important, in some cases, in particular on ancestral land, that may happen big for sons, for example, 3 sons. A sons got a lot of sons and grandsons. B got only 1 son. And C has no son. So in that case, A, B, C, A and B will have the majority. And C may be possibly very weak and could not give birth to any son or something. If we abolish 100% of the 100% vote of big business in Zhou and Tong, that means the big and powerful son can join together to suppress the weaker son. the weaker form. So that's why they have a construction in the case. For example, in 1987, there was a case about that, talking about for the legal policy. I mean, for me, it's an interpretation for equality. You have 100% vote for every major decision. It's called King Fat case, Ken Fat case. Major decision must be made 100%. Otherwise, the weaker Tong or weaker son or weaker member will be, suppressed by the majority. And that's why I think when this case moved when this situation moved about to the government, they may face the same issue, right? We need to protect those minorities.
So what is the source of the law concerning this 100% consent for major decision? Is it in an ordinance or is it in case law?
In case law, 1987 King Fed. I can't remember the actual.
So what law was the case interpreting? I mean, how did the court make such a decision?
Yeah, I try to make it simpler because we have those lawyers there. It's about the distribution of proceeds, the distribution of money of Tso, whether that should be per steppies, that means, or per capita. Per steppie means distribute the proceeds of money to each form basis, or distributed the proceeds of income per capita. That means every son. And on this case, the Robert Tang judge said that after making a lot of different citation of old texts and things, he said for the equality of the distribution per steppies per form will be more equal and in equality, because if you distribute the money per capita, that means per son, the family that have more sons will get more money. That would be unfair. So after this case, otherwise we have new case to change that, and that's the situation now.
So the decision was supposed to be based on the Chinese traditional laws,
yes,
right?
Yes.
So
that's the problem.
So the court was actually relying on
yes.
some traditional authority
and also
as its basis for its decision.
Yeah, well, the point is, look at New Territories Ordinance. They said they would be based on Chinese custom, not Chinese law. So solely Chinese law. That means the customary practices. This is what my Sifu told me. Look carefully of the New Territories Ordinance, and always warn me of not using Dai Qing Lunai very much, because we have to look at the custom. So they said, and on this case, they based on custom. It's not about the statutory law.
Okay, so in theory, the legislation can override all the traditional Chinese law that applies in new territories. So for the development of the northern metropolis, if the bill and the future legislation changes some of these existing rules concerning Zhou and Tong, I suppose the change cannot be challenged. I don't know whether the basic law can provide any basis for challenging any change of such law.
Yes. Well, I only talk about law, but when we look at the New Territories Ordinance, they're talking about Chinese custom. Right? You can change Chinese custom by statutory law, but this is a political decision. And you have to explain to the public why you change that, change the law in 1987. Well, it's not a lawyer's concern. It's more about the government policy concern.
So under the existing law, so is it clear that that something like ownership belongs to a certain group of people, and can we easily identify the group of people?
It depends. Well, that is a very fundamental weakness of 祭田, I mean 祭田, ancestral land system. Normally, you would have the problem after 3 generations, because we have sons. They are very powerful. They make a lot of money. they have sons and sons, they got good education, they got promotion in civil service examination, they can be a very good development in future. But probably you have son. We have son that has no progress or even very weak. And that system normally collapses after 3 generations because of the different development of the form. And it won't be easily changed because in traditional China, normally after 100 years, they will have some internal dispute and war and everything. So everything comes back again. But in new territories for the past 150 years, only Japanese occupation may interrupt that, but we have very long things. And that system, traditionally that have a defect, actually happen now in Hong Kong.
Okay, so yeah, maybe we'll open this discussion to
sure.
members of the audience. Those who are here in person are welcome to raise questions or give comments. You'll be given priority. Those who are online can also type any question or comments, and I will try to read them out in due course. Okay, yes.
Thank you so much for the talk. I've learned a lot. So on Professor Chen's question on whether there will be conflict or some challenges regarding the northern metropolis on the one hand and the traditional Tso and Tong on the other hand, I've just popped in my mind. I wonder whether, for example, like Article 40 of the Basic Law on the lawful traditional rights of new territories, indigenous inhabitants. I know that not all people in the new territories are covered by this provision, but I wonder in those cases where there are overlaps, whether this provision will come into play. And I wonder what's your take on this? Thank you.
Do you want to collect some questions, or do you want to answer one by one?
Collect more questions.
Okay, we'll collect. Maybe even you can take down the question, and then we'll collect a few more. Are there other questions or comments? Yes.
Thank you for the talk. I have 2 questions. The first one is about, so you said that the adoption ordinance basically preclude the customary practice of choosing nephews as the one who inherit the Tong, the land of Tong. So does that mean even if the widow does not have any daughter and any son, but she has a nephew, the nephew still cannot inherit that land because of even in the absence of a daughter? And that's my first question. And the second question is about, you said that the colonial government actually confused the characterization of Tong because it makes all the other land use of land together into one single category. So does this confusion bring any practical implication or in the operation? Does this confusion really complicate the operation of the law? Thank you.
Okay, thank you, Professor. My question is that in mainland in Shenzhen, that the village property is owned if the village is owned by a special company, it was managed by the manager. So I think what's the difference between the Shenzhen's this kind of management and between the management of the Hong Kong's Zhuchang and this kind of estate? Thank you.
So maybe we'll deal with the 3 questions first.
Oh, thank you for the questions. Let me deal with from the latest to the earliest. You asked about manager, right? Big problem because there was no such systematic question and no systematic arrangement of manager in traditional China. That was created by registration of manager was created by colonial authorities. Look at that report. No manager mentioned here. Even Zhou was not mentioned here. I won't deal with the Zhou definition there, but no Zhou, mentioned here, and no manager. But how come we have a manager? And since it is not a concept in traditional Chinese land law, then we have many, many cases in Hong Kong talking about the appointment of manager, talking about the power of the manager, talking about the scope of power of manager, talking about not the dissolution. Talking about the firing of the manager, talking about his role in making contract. So we have big issues there. And that's why we have so many case law. And because we can't find anything in traditional Chinese law. And we can only rely on customary practices. That means rely on those guys in the new territories and also legal experts. And all these cases talk about many years. It takes many years to resolve, and we have an issue. So on the second question of adoption, let's talk about, it takes more than 10 minutes, hopefully. Let's talk about the inheritance law in Qing China, right? So in Qing China, in traditional Chinese law, if I have no son, similar to my situation, I have only 2 daughters, I have no son, what would I do? My next step is to find my nephew to inherit. And I have an elder brother. It's a real life situation. I have elder brother, he has only 1 daughter. So I would face extinction of household. What would I do? I would have to find my father got a lot of brothers. So my father's brothers, I will ask my father's brothers whether they have son. If they have son, right, grab here, and I adopt this one. So that's the real life. So in fact, before I die, I have to do this. Otherwise, my household will be extinct and it will bring a lot of trouble. But suppose I die suddenly today after this lecture. Oh yeah, I die suddenly. So there is no way to do adoption during my lifetime, right? So the next thing I have to do is my wife to find this nephew to come, right? And before my wife making formal appointment, we look at the law, right? Sorry, maybe, no, I've got a mistake. Look at the law. Before my wife make the appointment, all properties will be succeeded by her first. And then the next step is to appoint an heir, right? Appoint a nephew. Suppose my wife doesn't like this nephew because this nephew gambling, very bad thing, making lavish life, spend a lot of money. She doesn't like that. How about if my wife does not make any appointment of an heir, then extinction of household, right? And then properties goes to the doctor. That's the law, because the law didn't mention about the time to make an appointment. Yeah, that's the issue. And in many situations, in many situations, when I have a lot of monies, I have lots of properties, the relatives, they will force my wife to get remarried in village, or they force her to appoint this nephew to succeed the property. So it happens all the time. And the adoption ordinance, fortunately or unfortunately, give rights to women, and that happens here. So that's the point. I hope I answered your question by referring to traditional inheritance law in China. Oh, on the first question about Article 40 and new territories. Well, the new territories ordinance, they have a lot of jurisprudence. I don't see any reason why they have in contravention with Article 40. So until now, there's no challenge there. If you want to know traditional rights in Article 40, you have to look at Gok Chakin's case about the things right in small house policy. The court make a very good analysis of the way traditional rights, how to interpret that. But today we don't talk about the basic law, but look at the case, you will see that New Territories Ordinance is very safe under Article 40.
If there are still questions, maybe we can have a second round. Yes, SK first.
Thank you very much. Can I ask you, to what extent can this be overridden by express provision in the will? And to the extent that the share in the Tso and Tong can be passed by will, what's the extent to which, can it be passed to a daughter? Can it be passed to someone who is maybe not even a relative, etc.?
Any more question, comment? Yes.
Thank you. Because I'm not major in law. I major in architecture. So my question may not that relevant to law itself. And my question is, like, as you mentioned before, all the cases are individual. Like in the Northern Metro project, in such mega projects, is there any additional regulations that would protect the authority, welfare, and community displacement? How to, if you acquire that line, how to like protect themselves, do not like displacement so far from their original place. Thank you.
Thank you. Any more? Those who are online, you're welcome if you have questions to type them onto the relevant box. So maybe I'll ask Max to deal with the two questions.
Yes. First of all, I answered the question of doctors right there. So is a disruption of common law or legislation by adoption ordinance, right? And in fact, it shows that statutory law can change the customs, and it was accepted by court that you can use statutory law to change. So whether any statutory law can abolish any rights in the new territories depends on political situation and decision rather than the law, right? So when we study marriage law, which I also put a lot of time on marriage reform ordinance, the British government simply changed that in one go, right? It tested a state ordinance change. New definition of concubine, look at my book. The definition of concubines in Hong Kong law was actually made by the legislative counselor behind the scene. So that was a present situation, a present definition, which was different from the traditional Chinese law. And so, so also they have a change in adoption ordinance in one go in 1971 and 72. Yes, they can change. Will is different part because in traditional Chinese law, will, you can make will. And there was a wills ordinance there to abolish traditional Chinese will after 1972. Because before 1972, in will, Chinese will, they have two, well, it's very complicated for lawyers, sorry about that. Before 1972, there are some very big tycoon. They want to make will of getting rid of this traditional Chinese law. And they, by will, they give rights to doctor, which is in contravention with traditional Chinese law. Because in traditional Chinese law, all properties must be shared by sons, 居子均分, or so must be shared by sons, not daughters. In traditional China, you cannot change that distribution of money by using will. Chinese will could not intervene the distribution of money. In British colonial period, the court said that, oh yeah, this rich man is not making the Chinese will. He is making Western will. So go on this way, right? So get rid of the traditional Chinese law. And after Wills Ordinance, I think in 1972-73, they abolished that distinction. And so it's all historical research rather than the present law. And of course, you can change, as I said, you can change things like this. They can do will to get rid of the doctors, but you know, the point is, it was already implemented in 1972. So there's a problem here on the daughter's rights now because of the change in adoption ordinance rather than on the will thing.
I think SK, well, your question concerned with Zhou or Tong land. So can a member of the family or clan who technically has a share in the Zhou and Tong land transfer by inheritance his rights to daughters?
Well, he can do it in technical terms. Suddenly, I make a will and distribute my property. Yes, but that should be challenged in court. You can do it.
I think she's referring to Zhou or Tong property, not ordinary personal property.
Zhou and Tong property, of course, not will, because Zhou and Tong is not a legal entity. They cannot make will.
So the will cannot deal with the Zhou and Tong property.
Yeah, Zhou and Tong is not a legal entity. Remember. Yeah. Yeah, that's the point. Yeah.
Are there any other questions?
Well, on the second question, I don't really see your issue, but I suppose you mean whether we should respect the traditional rights of the community. It depends on the government, because the government wants to develop the land, right? And he faced difficulties in Zhou and Tong. And I think the government has already mentioned a very long time that they want to change and deal with that Zhou Tong land. And the main problem is that, as I said, anyone who feels very confident of dealing with Zhou and Tong, please look at this table. I think some of you may already taken the photo. How to deal with that, right? Which part of which land, which institution is using the traditional Chinese law or not? In Japanese occupation of Taiwan, they deal with every single piece of land one by one, recategorize them. But in British Hong Kong, they only ask you to register under the top row of different institutions without governing the land. For example, in Japanese occupation period of Taiwan, for Miutin, temple land, they asked them to do a registration for charity, 宗教法人, right? That deal with the issue, 宗教法人, religious legal person, deal with them. For the bridge association, other thing, register as charitable organization, 財團法人, that deal with the issues. In ancestral land, they use 祭祀工業, 祭祀工業, and to deal with the questions. And for the woman, they succeed in Hong Kong. One particular issue is the confusing definition of 走. In fact, there are two types of 走 in this category. One type is ancestral land, right? Other type is the type of this one. When a woman inherits, according to law, that should be the woman inherits the husband's property. But in British colonial time, they asked the woman to form a 走, right? To form a 走, because they think that after women making an appointment of heir, all properties will be given to an heir, right? And 走 property, so he owned, women asked him to form a 走, and women make as a 司理. But they are not ancestral land, right? They are just part of the process of this inheritance situation, process. And the British government asked them to form a 走. So things happen, theory in law. If it is a 走, so would daughter inherit the 走? It's not ancestral, it's a family property arrangement, right? And the women probably, and the daughter will probably marry to another man surname Wong. So how Wong succeed the 走 with different surname, right? So it's a strange combination because the British colonial authorities simply throw away and didn't want to deal with that and asked her to do the 走. And now that confusion happened now because so in court, the court will ask what kind of 走 are you talking about, this part or that part? Ancestral, family, or are you talking about inheritance? Or what kind of Tong are you talking about? You're talking about for investment purpose of Tong, or those Tong they are making pharmaceutical Chinese herbs, or are you talking about a Tong that are actually making ancestral worship? That's the confusion, and we need to find a way to deal with that chaotic situation. Here you see in the table, and that happens now, and that's why it takes me a lot of time to explain in my class. When they look at the table, oh, so terribly wrong, right?
So that all these different names are now used in registering such different kinds of property.
Yes.
So not just Zhou and Tong, but also
Yes.
the other names.
The new case is Hua Yan Mo Fan Hung. This one is a new case on the right-hand side, bottom. It's Hung. They took about several years to confirm that Chinese customary practices can be used in Hung. But in fact, Hung is, on that context, is an investment company. But how can the court apply Chinese customary law? That should be appealed, right? Because Hung, in that context, you look at it carefully, it's not for ancestral purpose, it's not for family arrangement, it's not for graveyard, it's not for the bridge, or not for charitable purpose. They are all investment. And the court said that simply because they are registered under Section 15 successfully, so the Chinese custom apply.
Okay, thank you. So maybe it's time to close the seminar. So thank you very much to Max for giving us a most interesting and stimulating presentation. It shows us that this area of the law in Hong Kong is actually very difficult and complicated.
Yes.
I think it is difficult even for lawyers to master the law because it's not clearly set out anywhere, and you have to study the case law and then the Dai Qing Lut Lai and the Dai Lei Yun case decisions and so on. So thank you to all of you for attending this seminar. I hope you get interested in this topic, and you can do your own research or read the Dr. Max Wong's book and articles.
Study in our law faculty, right?
Okay, so thank you very much.